Good afternoon and welcome. Today we are going to be talking about 3 ways that you can stay out of probate court. And why is that so important? Why does it matter? What's so bad about it? Well, for one, it takes time. There's here in Michigan, it's about a minimum of 6 months that a case has to be in court. There are very definitive timelines for creditors to even make a claim, which is at least 4 months. So that means that if somebody owes you some money, or if you owe somebody else some money, that 4-month window has to be open for them to be able to make a claim on whatever is left of your property. Okay, so time just for even your debts to be paid. All right, money. Right, it costs to initiate a case in court, and then if you need an attorney's assistance, that's going to cost money. And then there's also just other administrative fees. If you need to do other kind of administrative things outside of court, that can cost money, right? Whereas by avoiding probate court, you can save those kinds of costs and put them elsewhere, and somebody else that you want to have the money can have it sooner, right? And it's a headache. Okay, and I say this as a practicing attorney with cases in probate court. It doesn't need to be as difficult as it is sometimes. It doesn't need to be as complex, and it's really not. It doesn't need to be as time intensive as it is sometimes, but the biggest problem is the people. All right. When you leave a case open for probate court, and a lot of times these cases don't have wills. There's been no estate planning done, so we're figuring it out as we go along in court. And here in Michigan, and I'm sure in all states across the U.S., there's a statutory. That means by the law, there are rules about how an estate is divided and how an estate is transferred according to the law. If you don't have your own estate planning documents in place, that's what's going to be following. And that's where a lot of people just come in and fight over everything. Okay. Because so and so should be here, should get that. Well, this is what mom wanted, but it was never written down. And it gets messy. Okay. That's the biggest hindrance of probate court, is just the mess it can make. Okay. And that flows out into personal relationships, family relationships, right? The property, the family home, all of that stuff is jeopardized, is threatened when you don't have any documents in place. And that's where probate court has to see it through. All right. But today, again, we're going to try to avoid all of that headache. I'm seeing a lot more of this happening, and a lot more people interested in, well, I don't want that, right? I've seen the fights, I've been a part of it, I don't like it. How can I avoid it? So we're going to talk about that here today. And we're going to talk about 3 ways, 3 different tools you can use to stay out of probate court. And it's not always foolproof. Some are. Okay, we'll talk about that. So wherever you are, if you're in Michigan, you can contact us at our office. Our information will be in the description of the video. But if you're in another state, you can seek legal assistance in that state. All right, because everything is not always exhaustive, but these 3 ways we're going to talk about here today, we're going to show you how they can avoid probate. All right. The first one is a very simple one that I talk about almost every week because it is so easy to do. You can do it now, and it is almost guaranteed to avoid probate court, and that is naming beneficiaries in your accounts. Okay, or you might know them as beneficiary designations. And why is that? Because it is very specifically named who you want to get this asset when you're gone. All right, so let me back it up just a little bit. There are 2 types of assets when it comes to probate court. There's a probate asset and a non-probate asset. A probate asset means something that has nobody else's name on it. You pass away, and now the probate court has to determine who's going to get it. So it could be your house, it can be your bank account, it can be your car, right? All your personal property. There's nowhere for it to flow, so it has to go to probate court to determine who's going to get it. And then we have non-probate assets. These are also sometimes known as pay-on-death accounts. A lot of times there are other kind of assets that you can name somewhere. We're going to get into that. But for instance, a bank account is a very good example of a non-probate asset if you name a beneficiary on there. So let's say you have $100,000 sitting in a bank account, which is not uncommon. Okay. $100,000 sitting in a bank account, and you name your only living child to be the beneficiary on that account. So that means once you pass away, the child is entitled to the $100,000 in the account. It does not have to go to probate court because you named the beneficiary. That is a non-probate asset. And that's what we're talking about. That's the very first thing you could do to avoid any kind of court hassling in that way. You can also do this with life insurance policies. You can do this with retirement accounts. Any account that you have that you can name someone as a beneficiary, someone to take over if something were to happen to you, that is a non-probate asset. But if you don't name a beneficiary there, it goes to probate court. Then it becomes what's called a probate asset because there's no other name. It's only your name on the account, but we don't know where else to take this. So you have to go to court to find out. All right. And like I said, beneficiary designations, if you name somebody on there, it's almost guaranteed that it will not go to court because there are other rules that govern the rule of the institution. So if it's the financial institution, their rules govern. Okay, that's the contract between you and the bank. Probate court is likely not going to break that. There have been a lot of cases that have tried to do it with people who named, old girlfriends or ex-spouses on beneficiary accounts and they never changed it. Almost always the court is going to go with whoever is on that name as a beneficiary because you had the opportunity to change and you didn't do it. Okay, so the court doesn't step in. It's a very, very simple thing to do, very easy way for you to name whoever you want on that account to get the money after you're gone right away. Don't have to go to probate court. Most you have to do is usually present your identification and a death certificate of whoever that was, and you'll get the money. Okay. But also, if you name someone as a beneficiary, make sure you tell them who's on the account. Make sure you tell them that they're there. If you can trust them with that information, make sure you let them know or let somebody else know, maybe it's your attorney. So that way, the bank is not giving you a hard time because they're not going to disclose that information to you. Bank, life insurance companies, they have that information. They're not going to share it with you, okay, unless they have a court order. Or unless, like I said, you know who it is, you know that this is the policy, you have the information to prove who you are, prove that there's nothing fraudulent going on, okay? And then they'll comply. But I've seen cases where, that information was even known and the life insurance company still didn't want to give up the money. I had a client like that a few years ago. Unfortunately, though, there was no beneficiary, so it did have to go to probate court. But even after we got the probate court papers, the life insurance company was still holding on to the funds. Finally, I had to step in, get involved, make not a phone call, but send an email right to the top of the food chain. And then the money was turned over in a week. Okay. So make sure that you just kind of have all your ducks in a row. You know who the company is, you know the amount, you have a beneficiary named on the account. All right. And like I said, almost always the money will flow to who it needs to flow to. Okay. So that's one way. In a very simple way, you can do that now. You can do it online. You can go to your bank if you have a relationship with your banker, credit union, whomever it is. You can let them know, right? Make sure you have that done because if not, then you leave the risk open of it going into probate court, and that's not what you want for something simple like that. You don't want $100,000, $80,000, 200, $250,000. I've seen it all. You don't want that to be tied up in a bank in an account where you could have named somebody to take over right away. Okay, because it can have a tremendous impact on that next person that you want them to have. So that's number one. Number two, what do I want to talk about? Number two, I have two other ones. I don't know which one I want to name first, but let's say a trust. Okay. Number two is a trust. We hear a lot about wills and trusts and what's the difference. They're both estate planning tools. They have very distinct differences. A trust is private. A will is designed to be heard in the probate court. A will, even if you do have one and it's written out, it has to go to probate court. It does not avoid the probate court process. It just very clearly delineates who you want to get what, how much, all of that. So it's your own will for your property. Whereas if you had nothing and you go to probate court, you have to go there. The court will follow the law's will for your property, right? Those statutory laws we just talked about, the court is going to follow that. So a will go to probate court. A trust does not. And I was just talking to a client about this week. The probate court still has some jurisdiction. It means they still have some authority to hear any kind of disputes that may come between whatever's going on with the trust. But because the trust takes so much intention and effort and specificity and who's going to get what and how, it's very, very difficult to even bring those kind of claims. Okay. But a trust will keep your assets private, whereas in a will or in a regular probate case, those have to be listed in an inventory, and the amount, what it is, what's in the estate, all that is made public. Trust doesn't do that. All right. Another big benefit of a trust is that you can use it now, and you can use it in your lifetime to also benefit from it, whereas a will does not take effect until after your passing. All right. The testator, that's who you become, the deceased, and then that's when your wishes are made known. But you have to be deceased first, right, for the will to be taken to probate court. A trust is not like that. A trust, you can do it right now. There are three people in a trust, three roles that a trust needs: a settlor or a grantor, which is the person that creates it, a trustee, which is the person that manages it, and a beneficiary, right? The person that is going to benefit from whatever's in the trust. You can be all three in your lifetime, okay? But you have to name somebody to benefit afterwards, or else there's really no purpose to it. So that and a trust is also very flexible, and it's very diverse. Again, having these conversations with clients, we just kind of get into all the things you can do with it. You can put property, real estate. You can put that in a trust. You can put your personal property in a trust. You can put your bank accounts in a trust if you'd like to do that. You can put different policies in a trust. And again, it's very diverse. So you always want to talk to a professional about what your plan is and why you want to do it that way, because trust can also help you avoid a lot of things like tax consequences, but you want to make sure you're not also taking tax hits, okay, by putting things in a trust that will remove tax benefits. Retirement accounts are a big one. You always want to check before you do anything with a retirement account. Almost always it's a good idea to just name a person on as a beneficiary, okay, so that money can flow to them. Don't want to get too technical about that, but again, you can always consult someone in your area. But I just want to bring awareness to the diversity of a trust and how much property you can put in there, title it into the name of the trust, and how it can continue, right? Just beyond your lifetime, it can go to the next generation. They can benefit from it, and it all depends on how you want to structure it. But it is a very great tool to avoid probate court because it's really designed to do that. It's designed to be private, to avoid the messiness, the family fights, all of that stuff. Okay, so that's number two. We talked about number one. That was account beneficiaries, right? Beneficiary designations. Number two is a trust. Number three is something I think is underutilized sometimes, but you also want to be aware of it. Make sure you get professional guidance on it so you're not messing up the intention of trying to avoid probate. But number three is actually retitling real property. So deeds, retitling the deeds, okay, into some kind of either joint ownership, or what we have here, excuse me, in the state of Michigan is called a ladybird deed. All right. It's where you retain control of the property throughout your lifetime, but then on your death, on the deed, the way that it is executed, someone else can then assume ownership after you pass away. Okay. Definitely talk with an attorney or a licensed professional in your area before you consider these kinds of moves, or wherever state you're in, to make sure you can do something like that. But it is something that avoids probate court. It's essentially like a pay on death account, but for the house. Okay, think of it like that. You can also do joint ownership of the home. You want to be careful with that though, because one move I see a lot of people make, excuse me, and it doesn't work out, is they'll do what's called a joint tenancy with rights of survivorship. The rights of survivorship piece is the piece that messes them up. Okay. So it essentially means everybody owns the house jointly. Right of survivorship means basically whoever is the last one standing, they'll get to own the home, but that can't be broken. Okay. So if there's any division, any conflict, siblings that don't get along, it's always siblings. Okay. Siblings that don't get along, that can't be broken. And so then the house is kind of in limbo. All right. Uh, I've also seen it with like um, parents and then older adults. It's always older adults too. Parents and their older children that just they don't get along anymore, and so now parent wants to retitle it, but because that can't be broken, it really can't be retitled. Um, the intention is to try to have everybody get along, and it avoids probate court. But because this right of survivorship is there, that can't be broken. That's a whole different interest, and it's not really separable. Okay. Um, and again, that's kind of more technical. You definitely want to check with a professional in your area, but I do want just you to think and to be aware that retitling property, right, or reconveying the deed, that is an option to avoid probate court, depending on also how many properties you own. So if it's like the family property and you just don't want to go to probate court and everybody's okay, they get along well, that might be an option. But again, a trust. You might want to put it in a trust, right? I have these conversations with clients all the time. It just depends on what your objective is, who you're thinking about getting it to. If it's just one sole person, but you have many different properties, maybe it's better to do it in a trust, right? Because the other disadvantage with retitling deeds is that you have to do it for every single one, right? Every single property you own, and if you're in, and they always go by the county that you're in the state. Okay, so if you have it in two different counties, you have two different recordings, right? Two different counties to take it down to, two different fees, right? Or whatever it is, two different processing times, right? That can get difficult as opposed to you put everything in one basket, which is a trust. All right. But nonetheless, those are ways to avoid probate court. And again, great things to start thinking about and considering why, because probate court can be so time consuming. It can be a big time hassle. It doesn't have to take a long time, but again, the people interest is really what takes longer than the legal interest. I say that often. All right. I have cases that we've closed it up in 6 months. I have cases that we're going on 2, 3 years. All right. For nothing. Like we've solved the main issue, but there's just this personality stuff going on still. Okay. And it prolongs the process, right? So I had a case where there was just no communication for an entire quarter of the year for no reason, just no communication, completely shut down. And then we have to elevate it, bring it before the judge. It just gets messy. You don't have to do that. And so if you can avoid that, it's a good idea too, because there are options out there to do it, and then you just get rid of all of that contention, and all of the stress, all of the heartache. People, their hearts get hardened because they're like, wow, I can't believe so and so would do this to me. I mean, and a lot of times it's sibling people that grew up together, people that lived in the same household, had the same parents, right? Same upbringing, same rearing. But then somewhere along the way, it strayed out, and now this is where the nastiness really can get in. And if you can avoid that going into 2025, okay, a new year, let's not do that anymore. Let's get our affairs in order. Let's minimize the conflict. Let's promote generational peace and harmony. Because if you don't do it, it's going to fall on the next generation to fix it. Okay. So that's our video for today on the three ways that you can, the three tools you can use to stay out of probate court. We are still doing also annual reviews until I think next week, the 19th. So one more week to get that in. It's a great time to review. This is the end of the year. We have a lot of things on the horizon for the next year. I'm getting a lot of calls because, this is just the time of year where family is getting together and things are being discovered, uncovered, and then, also in a good manner. People are really seeing what's important to them and wanting to make sure that those things are taken care of, right? And so that they can just sit back and appreciate everything that life is right now. Okay. So if you are considering that, you can check the link in the bio and schedule an annual review if you're here in the state of Michigan. All right. If not, just keep following. We'll have something coming up for you, maybe, right? Not legal services, but for sure, some of these just general tips that you can take with you, the account beneficiary thing being one of them. Okay. Otherwise, we will see you again next week, Thursday, December 19th. Wow, we're really getting there. All right. We'll see you next week. Take care.